This session is dedicated to the dispute settlement mechanism. We will try today to explore the dispute settlement mechanism established under the African Continental Trade Agreement. So, as you see, we will examine together, we will try to explore together 3 topics. The first is the process, how this mechanism works. From the starting point, from the request to consultation to the enforcement, and after the enforcement, we will try to follow this mechanism step by step by step, focusing on practical issues, how it works. That's the first issue that we will try to explore. The process. And I hope that everyone, after this presentation, will be able to understand how the mechanism works. That's the most challenging issue because it will take some time. Then we have 2 issues: the access to the dispute settlement mechanism or the dispute settlement body. Second issue. The third issue is the enforcement. When a decision is issued, how to enforce it? Because enforcement is very important matter. If you have a decision rendered by the dispute settlement and you cannot enforce it, this decision will be worthless. So that is our planning, our program for today. 3 topics. Let's start by the first topic. It's very difficult for me to manage this session because I need to be here for the PowerPoint, so I cannot move. So maybe I will stay here in order to make my work easy. The first topic is the dispute settlement mechanism under the AfCFTA. And the starting point here is Article 20. Article 20 of the Kigali Agreement. Article 20, you think so? Yeah, maybe better. Let's read it together. This is Article 20. It is included in Part 5, and the title of Part 5 is Dispute Settlement. Look, here we have Part 6, Dispute Settlement, Article 20, Dispute Settlement. Same title. When we draft treaties, you should avoid to give the same title to the article and the part. Okay, that's not important. Let's try to examine it together. Please, try to read this Article 20. Then tell me if you have some comments. What is the message that you get after reading this article? Okay? They said paragraph 1, a dispute settlement mechanism is established in order to settle disputes between state parties. That's the first idea. Then they said the dispute settlement mechanism shall be administered in accordance with the protocol on rules and procedures on the settlement of dispute. That's good. So they establish a dispute settlement mechanism between states, and this dispute settlement mechanism will be administered in accordance with the protocol. Second idea. Third, the protocol on rules and procedures on the settlement of dispute shall establish a dispute settlement mechanism. Not so clear. So here we have the mechanism is established, already established. Then they said that the protocol on rules will establish the mechanism. So we did not understand. Yes. Sorry? Yeah, I see, but it's not clear. I see. So just a comment, a general comment. So the body is for drafting. So you need to be clear, and you need to focus on the issue clearly. It's not important. What is important is the following. We have a dispute settlement mechanism. This dispute settlement mechanism is established to settle disputes between state parties. I underline state parties. Then this dispute settlement must be administered in accordance with the protocol or rules and procedures on the settlement of dispute. So you see here that we have a key instrument, a very important instrument to understand the dispute settlement mechanism. This instrument is the protocol on rules and procedures on the settlement of dispute. So the agreement establishes the dispute settlement. Then for the work, the administration, for the procedure, you need to see what the protocol on rules and procedures on the settlement of disputes. Rules and procedures, not easy to understand because the procedures are rules, but procedural rules. You see here, even if the title, rules and procedures, but procedures are included, are rules also. All what the protocol provides are rules. So why we make a distinction between rules and procedures? Maybe it was better to say the protocol on settlement of disputes. Rules and procedures. Okay, that is not important, just a comment, formal comment. Then, when you look at the agreement, we find another article on dispute settlement. Article 13, consultation and dispute settlement. And we find it in part 10 on institutional provision, except or as otherwise provided in the protocol, in this protocol, the relevant provision of the protocol on rules and procedure on the settlement of dispute shall apply to consultation and the settlement of dispute under this protocol. So, relationship between 13 and 20 are not so clear, and I don't think that this article adds something new to what was said under Article 20. This is not important. What is important to note is that we have a dispute settlement mechanism under the AfCFTA. We have a dispute settlement that is structured, it's organized. And when they establish this dispute mechanism, the drafters of the agreement and the protocol were source of inspiration was the World Trade Organization mechanism. You know that we have a system of multilateral trade provided by the Marrakesh Agreement. It's the World Trade Organization system. And the World Trade Organization system has a dispute settlement system. And what we decided to do is a kind of transplantation. We copy and paste the mechanism that was used within the World Trade Organization. Just a question. Copy and paste. There is no Africanization of the mechanism. They take a mechanism that was used within the World Trade Organization for many years. And they decided to use it with some changes in the African context. This is the approach that was followed. But do you think that the World Trade Dispute Settlement mechanism is appropriate in the context of Africa? The decision was taken to take the World Trade Organization mechanism. And this mechanism is open for many African countries, because many African countries are members of the World Trade Organization. 40 African states are already members of the World Trade Organization, and they can use the World Trade Organization dispute settlement system. So for them, the African agreement did not offer any other serious procedural mechanism. Do you understand me? They are members of the World Trade Organization. They can use the World Trade Organization dispute settlement system. And now, for the African agreement, we offer them the same mechanism. Okay. This dispute settlement mechanism was activated during the meeting of the dispute settlement body in April 2021. So the mechanism is activated. However, since April 2021, I am not aware of any meeting. There is no information on this mechanism. It's very difficult to find information on the dispute settlement body. We know that is activated, that there is a meeting of the dispute settlement body in April 2021, but I don't have any further information on this mechanism. So, in order to understand this mechanism, we should look at the agreement, 1. 2, we should look on the protocol on dispute settlement. 2, there is other relevant instrument to understand the dispute settlement mechanism. There are 3 additional annexes to the protocol on dispute settlement. It's very difficult to find them. Believe me, I spent 1 hour to find them on the internet. We have 3 additional annexes to the protocol. Annex 1, working procedure of the panel, expert review group, and code of conduct for arbitrator and panelist. So, a good lawyer, before explaining a legal issue, must determine the sources, the legal sources. And here, we can conclude that the legal sources that we need examine in order to understand the dispute mechanism, settlement mechanism are three sources. First, you need to review the agreement, the base, the agreement. Then, you need to review the protocol on dispute settlement. Third, you need to review the three annexes to the protocol, the three additional annexes to the protocol: Annex 1, working procedure of the panel; Annex 2, Annex 3. So to understand the mechanism, you need to examine the three legal sources carefully. And that's what we will try to do together. Is it clear? At least you know that to understand the mechanism, you need to see, to review the three instruments. They are not three because we have the agreement, the protocol, and the three additional annexes. Difficult to find, believe me. Okay, let's start now by the protocol. In Article 2, the protocol on dispute settlement provides the objective of the dispute settlement mechanism within the African continental trade. Article 2 provides that the protocol provides for the administration of the dispute settlement mechanism established in accordance with Article 20 of the agreement. The objective of the dispute settlement is to establish a dispute settlement process that is transparent, accountable, fair, predictable, and consistent with the provision of the agreement. So the objective of the dispute settlement mechanism are transparent process, accountable, fair, predictable, consistent with the provision of the agreement. What I want to underline is transparent process, transparency. That means that we can have all information about the process, about the mechanism, about the members of the panel, about everything. I like transparency, and I said, if one of the objectives of the protocol is transparency, when I will go to the website of the Secretariat of the African Continental Trade Agreement, I will get all the information that I am looking for. So my first decision was to see what is offered in the website. In the website of the African Continental Secretariat, I find many information. Some of them are dated 10 April 2026. 10 April 2026, I get very important information. The Secretary General receives the Egyptian ambassador on a courtesy visit. And here we have the photo of the Secretary and the Egyptian ambassador. They look very happy. I get also another information, very useful information, is that dated one day before, 9 April 2026. Very important information. The Secretary General receives the Angolan ambassador on courtesy visit also. They look very happy. Huh? Look at them. They are very nice people with the African there, and they are very happy. But unfortunately, Nothing important. On the dispute settlement, on the members of the panelists, on the work, even if the agreement, the annexes of the protocol on dispute settlement were not available. That's a transparency. So if you provide that one of the objectives of the protocol is transparency, we have a website. We can give us information, news. Yes, we know that the Secretary General has a meeting with the ambassadors. They do it quickly. They put it on the website. But serious issue, with all respect, are not available. What we need is to know how it works, decision, draft, steps, nothing. I hope that I made a mistake. I hope, but I spent a lot of time looking at this website. This is the website of the Secretariat. There are only information on meetings, photos, people that are very happy. They look very happy. But me, I was not happy. Because for me, what is important is serious issues. I am a lawyer looking for decision, procedure, mechanism. Nothing is available. I hope that they will post such information in near future. Near future in Africa could be 1 month, 2 months, 3 months, years. You wait. We wait. We hope that we find information taking into consideration the fact that transparency is one of the objectives of the mechanism. Okay, let's move to other issue. To understand this dispute settlement mechanism, you need to start by the scope. The scope of the dispute that could be submitted to the dispute settlement mechanism. And here, regarding the scope, we have Article 3 of the protocol. Article 3 of the protocol provides that the scope of the dispute settlement mechanism, the scope of application is to settle dispute between state parties. That's the first element. Second element, dispute between state parties concerning their rights and obligations under the provisions of the agreement. So here we have 2 parameters to determine the scope of the mechanism. We have the personal parameter and the material parameter. First, the mechanism has jurisdiction or can be used to settle, as I said, state-to-state dispute. Then, and what we learn from this article is dispute between states concerning their rights and obligation. So the dispute is related to violations of the obligation. It's a legal dispute. In order to use the mechanism, we need 2 conditions. 2 conditions must be met. First, a dispute between 2 states. Second, this dispute is related to rights and obligation. and obligation for a party is a right for the other party. What's the difference between obligation and rights? If you have to pay me, your obligation is to pay, and my right is to ask you payment. So is there any difference between rights and obligation? If there is an obligation, necessarily there is a right for another person. So, rights and obligation, I don't know, I am just asking the question. Maybe you can say just obligation. Rights and obligation, okay. What is important is legal dispute, violation. This is what is indicated in Article 3. Let's see now the World Trade Organization system. They copy the World Trade Organization system, but they don't copy everything. Some provision applicable to the World Trade Organization system or mechanism are not copied. They take. If you look at the World Trade Organization system, you will find that the scope of covered disputes is not limited to violations. In the African context, you need to demonstrate a violation. The state did not grant the national treatment. The state did not grant the MFN treatment. So you have to demonstrate a violation. In the context of the World Trade Organization, they have another concept. They have the concept of nullification or impairment. What does it mean? Like the African system, in the World Trade Organization system, if there is a violation of the agreement, state can use the dispute settlement mechanism. But sometimes, even if there is no violation, the state can use the dispute settlement mechanism. What does it mean? Look here, if there is a violation, as the filer of another contracting party to carry out its obligation. Look here, they said obligation, because obligation are rights for the other party. They don't say obligation and rights. What is important is violation of obligation. Here they said rights and obligation. That's clear. From a legal point of view, it's clear, because as I told you, obligation and right are together all the time. We cannot have an obligation without right, and we cannot have a right without obligation. So you have to put rights or obligation, but not both of them. From a legal point of view, this is problematic. World Trade Organization, they said obligation. Then, so you can use the World Trade system if you have violation of obligation, and then here we have a situation when we can use it even if there is no violation. The application by another contracting party of any measures, whether or not it conflicts with the provision of the agreement, so you can use it even if there is no violation, and the existence of any other situation. So you look here, if you compare the two mechanisms, that the scope of the dispute settlement mechanism under the World Trade Organization is more broad than the African dispute settlement mechanism. What is this situation of nullification or impairment claim without violation? Let me give you an example to explain to you how the World Trade dispute settlement mechanism could be used even if there is no violation. Example, we have country A and country B are World Trade Organization members. country E reduces import taxes on smartphone, for example, from country B. Then country E introduces a rule that all smartphones must be registered in a local system. The rule applies to both local and imported phones, so it respects the national treatment on paper. However, local smartphones are already in the system automatically and they can make the registration easily. Imported smartphones need extra steps, time, and cost to register. The smartphone from country B become harder to sell in country E, even the tax is reduced. The benefit of the tax reduction is taken away, even if there is no violation. So, the idea is to understand here that the World Trade Organization system could be used in two situations: violation and sometimes, even if there is no violation, if the state can demonstrate that there is impairment or nullification of a claim without violation. That's the first comment. That is not important because our seminar here is dedicated to the African mechanism. We are not here exploring World Trade Organization system, just to draw your attention on some differences between the two mechanisms. What should we conclude? That's the important thing that we should understand. To use the dispute settlement mechanism, the African, I will call it the African dispute settlement mechanism. To use, you need two conditions. First, state-to-state dispute. Second, violation of the agreement or its annexes. So you need to know all the rules, all the provisions, all the agreements and the annexes, because dispute settlement is supposed to control the enforcement of the agreement and its annexes. Is it clear? You understand. So, if you want to use the dispute settlement mechanism, two conditions must be met. Violation, you have to demonstrate this violation. And the state-to-state. Okay, before moving to the process, I want to focus on the dispute settlement body, some institutional issues to understand the mechanism. Composition of the dispute settlement body. According to Article 5 of the protocol, the dispute settlement body shall be composed of representatives of state parties. So each state has a representative in the dispute settlement body. And the dispute settlement body shall have its own chairperson. It will be this person, the chairperson, will be elected by the state parties. So we have the composition of the dispute settlement body is the following. A member that represents each state with the chairperson of the dispute settlement body that is elected by the states, by the parties. That's the composition. What is the function now of the dispute settlement body? The dispute settlement body, according to the protocol, has three main functions. Three. First, establish dispute settlement panels and appellate body. I will explain to you later what does it mean. Establish panels and appellate body. Then adopt panel and appellate, adopt report issued by the panel or the appellate body. Then maintain surveillance, implementation of rulings and recommendation of the panel and appellate body, and authorize the suspension of the concessions and other obligations under the agreement. So, three major functions: establish, adopt, report, and control the enforcement of the decision. So we have a kind of body with members representing each state with chairperson, and this body has three main functions: establish dispute settlement, adopt report issued by the panels and other organs, then enforcement of the decision. Now let's move to the process. We understand the scope, we understand the institutional issues. Now we will try to describe the process from the beginning to the decision rendered by the panel or the appellate body. What is the process? The procedures under the dispute settlement mechanism. Step by step by step by step. And if it is not clear, if the step is not clear, please ask me to explain again. Let's start by step one. Step one is consultation. If there is a dispute between two states regarding obligation and rights, regarding obligation, provided under the agreement, the first step is that the state, the claimant state, request from the respondent state, request consultation. We start by consultation. Negotiation, consultation. We negotiate together to find a settlement, amicable settlement to the dispute. Consultation must be confidential and without prejudice to the right of any state in any further proceedings. According to the protocol, consultation may be held in the territory of the party complained against the respondent unless the parties agree otherwise. The consultation period is, according to the protocol, must be conducted within 60 days from the date of the request to consult. So if there is a dispute, the first step is the state that considers that another state or other states violate any provision of the agreement. The first step is to send to the other state a request for consultation. And the two states must, within a period of 60 days, try to find a solution to the dispute. That's the first step. Okay. If the parties settle the dispute, the issue is settled. However, what's happened if the other state did not respond? The state, the claimant state, request for consultation, and the other state did not respond. I know the African context. Many times, you don't expect to get a quick answer. It takes a lot of time, sometimes. So, one, if the other state did not respond. That's the first situation. The second situation, what's happened if the party respond, but the parties together did not settle the dispute by consultation. So if they settle the dispute by consultation, everything is okay. If the state, the respondent state, did not answer, or the state answered, but we try negotiation for 2 months and there is no solution. If the state to which request of consultation is made does not respond within 10 days after the date of receipt of the request, it's very strange, this provision. Excuse me. So the state does not respond. How do you know the date of receipt of the request? How do you know it? How do you know it? The state did not respond. You can know the date when you signed your request. But the reception date, are you working with the other state? You have someone there that will tell you what is the date you have to sign by post. By post. How do you know this date? The only mean is to send it by courier, by post, by DHL. You can know. But if you send by email or by electronic means, it's very difficult. How do you know? So 10 days after the date of receipt of the request. How do you say? Listen, me, I have a problem with you. I will request consultation with you. And if you don't answer within 10 days from the date of receipt of the request, I can ask for the establishment of a panel. If I send you by email, I cannot determine this date. And in Africa, you think on 10 days, you will be able to determine the date if you send by DHL or FedEx, or I don't know which. It takes a lot of time sometimes. Okay, take it as it was indicated. 10 days, if there is no answer, the state, the claimant state, can ask for establishment of a panel, can refer the matter to the dispute settlement body. Then, if the two states cannot settle their dispute, file to settle a dispute through consultation within 60 days after the date of receipt of the request, we have the same result. You can go and ask for establishment of a panel. So, to conclude on this issue, we start by consultation. 2 months, we speak. If after 2 months there is no settlement, the claimant state can ask for establishment of a panel. I will explain to you what does it mean. If the other state, the respondent state, did not answer, did not react within 10 days from the date of the receipt of the request for consultation, you determine the receipt date that I am not able to determine. Then you wait 10 days. If there is no reaction, you can ask for the establishment of a panel. if you can determine the receipt date, I would be happy to determine, because now we are living with dematerialization of the proceedings. Everything today we use electronic means. And unfortunately, I will tell you, we don't have any provision related to the dematerialization of the process. Even if the annexes of the protocol, they don't provide for rules related to the use of electronic means to communicate. Yesterday I was here, we have a protocol on digitalization. However, the process is not digitalized enough. Okay, let's move. Step 1, consultation. Step 2, there is a window for good offices, conciliation and mediation. The protocol provides that good offices, mediation, conciliation could be used to settle dispute. Window. What does it mean? This is important to mention. This means that during all the process of dispute settlement, the parties can agree on the use of the 3 techniques: good offices, conciliation, and mediation to settle their dispute. An agreement is required. If the parties agree on the use of good offices, conciliation, mediation, they can use them to settle the dispute. If mediation, conciliation, good office are used to settle a dispute after the request of consultation, that means that the state requests consultation from the other, and the 2 states decided to use mediation, conciliation, good office. In this scenario, mediation, conciliation, and good offices must be used for 2 months. So, if the parties decided to use consultation, mediation, and good office instead of consultation in the first step, they have to do it for 2 months. 60 days after the date, again, the date of the receipt of the request that I cannot determine. So they replace consultation by a good office, conciliation, mediation. In addition to that, conciliation, mediation, good offices could be used at any time. At any time, if there is an agreement between the parties. And they can be terminated by any time, by any of the state parties to the dispute. If good offices, conciliation and mediation are used and terminated by a party, then the other party or one of the party can proceed with a request for the establishment of a panel. That's good. Huh? Mediation, conciliation, and good offices. Very good. Window. Bad. Please. I am a lawyer for a long time. We don't have a definition of the notions. What does it mean? What is the meaning of conciliation? What is the meaning of mediation? What is the meaning of good offices? We don't have a definition of the notions. And there is a legal debate, interminated debate on those notions. What does it mean? Don't look at this. Who can explain to me what is good office, what is mediation, what is conciliation, and what is the difference between the three mechanisms? Who can? Yes, please. The difference, not the definitions. Yes, please.
So in my understanding, the difference is the degree of intervention of the neutral third party.
Good.
Yes. How I understand good offices is maybe from its utility. I think it's just the fact that the third party exists.
So you need, let me follow you. For the three mechanisms, we need a third party.
Yes.
Fine. Then, good office.
So
What is the function of this party, this third party?
this is my own personal understanding of how good offices works from the little I know about public international law.
Yes.
Simply the status of the third party,
Yeah.
just the status itself, and that you exist, like you're doing your negotiations in the vicinity. They make sure you can't be too much at each other's throat, sort of what Kofi Annan did.
Okay. So the third party will help the parties to negotiate.
No, they will provide the venue. They will not intervene too much. They just...
Exactly. What is the function?
Again, my own understanding.
I need your own.
So for me, what good offices looks like is if there's two students who are
dispute,
who are in dispute.
Yes.
Then instead of so mediation would be where.
No, not mediation. No, we are good officers.
Well, okay. So for good officers, they would be taken to your office as a professor.
Yeah.
And then you just so now talk. That's all you say.
You not talk. But the parties.
But they are in your office, so they know they can't go too far.
Good. But the parties, they are obliged to negotiate. There is a consultation for 2 months. So why do you need good office? To negotiate if the negotiation is already provided and it's an obligation. Okay. Mediation and conciliation now. Tell me the difference. Tell me. And I understand your conception. Okay, I will ask other people to explain to us what do they think. Then, is there any difference between mediation and conciliation and good offices?
Yes.
Yes, please.
So in mediation, the mediator takes active participation in the solution design. The solution, the parties come to it themselves, but the mediator sort of helps them lay out the options, think out the problems. You can think of it like an assistant in the negotiation process.
Good.
For conciliation, the conciliator does not take active participation in the design of the solution.
Yes. Any other conception here to explain to me what is the differences between the three techniques that are provided? Yes, please.
Thank you. I agree with what he said. I just want to add that these terms, from step 1 on consultation to these 3 other stages, they are stages that are very linked to the diplomatic route to settle the dispute, not the judicial route. So from a diplomatic perspective, these terms already have meanings that the African states would know in settling the disputes without creating a new definition. Thank you.
Other concept? Yes, please.
I just want to add that it's not the first time that you find these terms in the treaties, so they are used to it. They don't need to have a clear definition in the
I don't agree at all.
Because again, in the WTO rules, they have the same terms, so they are used to the terms. So it's not something that is being designed afresh.
They are very controversial terms, and this agreement must have a pedagogical rule for states that they don't understand, for people that don't understand, and even if in international law there is a debate, non-ended debate, on the difference between mediation and conciliation. What is the function of the mediator and what is the function of conciliator? Even if the definition is clear, I think that it was very useful in this protocol to give the state parties all the notions and all the instruments to make their work easy. We are supposed to read the protocol and to understand the system. We are not supposed to read and to go to another instrument to find the good definition or to the international customary law to find the good definition.
But what's the function? What's the function of it? I think we should interpret it from a functional point of view, which is to settle a dispute from a diplomatic perspective.
That's your conception. It's not mine. Me, I cannot understand what is the difference between them. What you say could be good, but when we draft an instrument for African states, for people that sometimes they are not loyal, at least you are expected to give them good instrument, good notions in the protocol. This was not, in my opinion, I understand. Yes. Singapore Convention is not applicable. Yeah, but it's not state-to-state convention, Singapore Convention. Yes, yes, true.
Could be enforceable?
Yes, yes.
But before Singapore Convention, I would understand that there's no difference between conciliation and mediation.
Yes.
But after Singapore Convention, mediation becomes enforceable after the parties signing it. But conciliation is not the same. So maybe I understand this could be the difference.
Believe me, I worked for conciliation and mediation for 20 years. And I find some people, they said this is the same mechanism. Other people, they said the conciliator has active function. The conciliator listens to the two parties, then the conciliator, as you said, proposes a solution to the party. The mediator did not propose anything. The mediator helps the parties to find a solution, but it's for the parties to find the solution. That's why when you have a conciliator, you pay him more, because he proposes something. For other people, they said, we have the same mechanism. Other people, they said, no, the mediator is active, more active than the conciliator. So, you mentioned Singapore Convention. Singapore Convention is a convention that was concluded in order for the enforcement of settlement agreement. First, this Singapore Convention was ratified by only one African country, is Nigeria. Second, I'm not sure that Singapore Convention is applicable because here we have a state-to-state dispute. Singapore Convention is applicable on private disputes, not state-to-state disputes. It could be applicable to dispute between investor and state. And I'm not sure that Singapore is relevant, but Singapore is relevant because the notion of mediation and conciliation that we find in Singapore Convention, we did not find it in other instruments. So, my position, it was helpful to at least explain to us. And why good offices, conciliation, mediation? Why you limit? Give the parties the flexibility to use any ADR method to settle the dispute. You know that today we have a combination of mediation, conciliation. We have a very elaborated technique to settle dispute by non-binding techniques. So here they indicate good office, conciliation, mediation. If I was involved, at least the parties can use any non-binding technique to settle their dispute, including good office, mediation, conciliation. Give the parties the flexibility. Give the parties the power to create appropriate mechanism to avoid dispute. You know that ADR today, alternative dispute resolution, are very elaborated. There are many techniques. The traditional conception under public international law that limit the mechanism is today not relevant. So, but at least we have a window for mediation, conciliation, good office. It's okay, good. But me, I'm a professor, 25 years, visiting more than 100 countries and 121. When I speak or I give lectures on mediation, we don't have the same understanding. You can agree with me, you cannot, it's your right. But I try to give you what is my position. And as African, like you, I am not destroying the system no, at all. I want to ameliorate, to put it, or to create a system that takes into consideration our realities. You need to know Africa. The administrative area, the people. I work with many African countries and I know that 10 days to answer, 10 days. It's, some countries, they do it. They need at least 5 days to look at it. Then they need 5 days to determine who must answer, because no one wants to answer. Then they need 3 meetings or 4 meetings to decide what is the answer. Then they need to send the answer to the minister in order to understand and decide. And the minister cannot take the decision. He needs to consult committees, groups. Then they finish by not. They don't answer. Step 2, good office, conciliation, mediation. As I told you, the protocol did not provide any definition, and what we find in public international law, I need to be honest, what we find is the definition that you mentioned. The good office, that's the definition that I find. Looking, consulting the international public law books, that's what I find. Procedure in which a third party helps the disputing states to start negotiation, but does not participate in the discussion or propose solution. That's the definition. But here, my comment is the following. Do you need a third party to help the party to negotiate, given the fact that the party are under the obligation to negotiate under the protocol? Do you need that? What is the adding value of this good office? Good office, the third party will help the two parties to consult, to negotiate, but they are under obligation to negotiate. What is the adding value? What this third party will do? They help them to start negotiation. They must start negotiation. No need. Mediation, a process where a third party examines the dispute and proposes non-binding solution to help the parties to reach an agreement. That's mediation. So the mediator did not propose anything. The mediator helps the parties to find an agreement. It's the party to find the agreement, to create the agreement. The mediator did not propose anything. Conciliation, third party actively assists the parties during negotiation and helps them to find a solution. He proposed a solution. So the mediator listened to E, try to clarify the point of view of B, then go to B, but it's the parties that find the agreement. The conciliator has acted. He listened to E, he listened to B, then he said, to put an end of this dispute, I propose the following solution. It's the parties to accept or to reject. The mediator did not propose anything. That's the definition. It's for the dispute settlement mechanism to clarify. If there is a need, maybe one day we will get a clarification from the dispute settlement body for the panel, from the panel or for the appellate body. Okay, step 1, consultation. Step 2, window for mediation, consultation, I don't know what's said. All of those things, you can use them. Then, if there is no settlement, we move to the third step, establishment of a panel. Third step. So you are following me, I hope. Consultation, this window, then we move to step 3. I try to explain to you the mechanism in logical order. The scope, let me give you my conception. The sources, we determine them, 3, agreement, protocol, and nexus. We find the rules, the regime of the dispute settlement in the 3 instruments that I mentioned. Then, I explain to you the scope, state-to-state, violation. And all the time I make some critics, you know me, I want to create the disorder, that's me. Sorry for that. Some people, they like that, others they don't like. But they have to support me for 1 day. Imagine, I am creating the disorder, but you are not in permanent contact with me, so feel. Some people, they are they suffer. But a lawyer must sometimes create a disorder, must. We are not here to say that's wonderful, that's good. And we don't have any explanation, because if you go to them, I try to understand if there is studies, books, publication in the website of the Secretariat. Hopefully they are not here, if not they will kill me. Okay, so if there is no solution, consultation, 2 months, mediation, whatever, no solution. The state did not agree on settlement. You move to this third step, establishment of a panel. So here, if there is no resolution, the claimant party, the complaining party, in writing, by email or in writing, paper, sign, I don't know, in writing, refer the matter to the dispute settlement body. That's good, I understand that. Then, request for the establishment of a panel. No solution, the state request in writing. What does mean in writing? I don't know. Today we don't use this provision of writing, because when we say it in writing, email is writing or not? Signed or not signed? Okay. The request shall indicate whether consultation were held, identify the specific measures at issue, and provide summary of the legal basis of the complaint sufficient to present the problem clearly. They require that the problem must be presented clearly, but some notions are not presented clearly. Then, after this request, a meeting of the dispute settlement body shall be organized within 15 days of the request to establish a panel. They have to organize a meeting, then the panel, they have 15 days to organize the meeting. Then the panel shall be constituted within 10 days of the meeting. So if you have a request, you have to organize a meeting, then constitute a panel in 10 days. As you see, the deadlines are fixed and they are tight, preconditions. So, no settlement, the state requests for establishment of a panel. Okay. Short, practical exercise. 3 minutes. And I will select one of you. All of you are potentially victims of this practical. And especially, I will ask people that did not speak. They were with us physically, but in their own words, intellectually. Some of them are looking on Facebook. I know them because yesterday I was there, so I have a look, a general look on what's happening. So, some others, they are reading newspaper, news, CNN, everything, I know. Writing WhatsApp message with hearts. And here we are to study here, to understand the laws and other activities could be organized outside the door of this conference. So here, 3 minutes I will give you. Each of you is a potential victim. Country E imposes discriminatory taxes on import of sugar from country B, and they are both members of the African Continental Agreement. Then we have a restriction on the quantity of sugar that might be imported. We are invited to write a request to establish a panel. I am a very generous person. I will give you 5 minutes. All of you, I will select one of you. I hope that he answers, or she answers. If not, I won't be happy. I will initiate a process against him, action against him. The best way to deal with this is to see the protocol on dispute settlement that you have. You have the protocol. You know, I don't take the responsibility to select a person, so I will delegate this matter to my friend Elvis. He will be responsible for this very serious decision. So, Elvis, you have all them before you. You determine some of them, one of them to answer. Let them sometimes do. It's better to find the people that were sleeping all the session. They are, you know them better than me because they are very nice, the people that are sleeping. I know some of them, and believe me, I met them in the restaurant and they are very friendly. They speak a lot, but not here.
Also, a few minutes to continue. And then
Do you finish? Elvis.
So, okay, I'm going to come up with two candidates. One candidate is already known. Let me pick another one. What does Justice say? Can I pick someone from the neighboring country, where we come from, Northern Rhodesia?
You know, Elvis is like the Security Council. When he takes a decision, we should enforce it. We must enforce it. Okay.
Let's see.
The request. If you are invited to write a request, what should you put the request in writing?
Gender balance.
1, 2, 3,
We want
4.
to volunteer. Okay, Prof has volunteered himself.
No, better to ask the participant. Prof is an expert. He's very known, he knows everything.
Gender balance.
Better to ask people that are not...
Okay. Prof Walid?
Yes.
Yeah.
Yes.
Okay. Okay. So we have the two candidates.
Your battery is running low, so please help me.
Oh, the battery.
Yeah, the battery is suffering.
Alex, the battery of the laptop is low.
Please, go on. 1, 2, 3, 4. The element. 1, 2, 3, 4. What should you mention in this request? 1.
Okay, so the first element that should be mentioned is whether the consultations have.
Yes.
And then the second one is a clear description or a summary of the legal basis of the complaint. Then the third is the exact measures that violate country A's obligations
Yes.
and how that violation is affecting country B.
Yes. The other person, is there anything to add to what was indicated
You don't have a microphone?
by
Okay, let me give you the microphone only.
our friend from Kenya?
Is the microphone on?
Any additional?
I think one is specific of issues because it's very particular how to mention specific article
Yes.
your citing has been violated, and then you also need to be specific about the measure
Yeah.
that you're complaining about and the violation, specific violation. It has to be very specific. It can't be broad general.
Yes. True. I am very happy. Really. I get the good answer. The request, as indicated in the protocol, must identify the specific measures. What is the measures that violate the agreement? And summary of the legal basis of the request that is sufficient to present the problem clearly. So if you have this, here you have discriminatory taxation, so violation of the national treatment, then you have limits on quantities that is a quantitative restriction on import. Maybe the Secretariat should put at least a model for the people to understand the different procedural act from a practical point of view. It could be helpful, it could be useful, better than the photos of the Secretariat with the ambassador of I don't know which country. It will be more helpful, more useful for us, for Africa, to understand the different procedural acts that will help the state. Okay. So request. The state made request. Then request to establish a panel. What is the panel? The panel is a group of 3 or 5 members. 3 or 5 members that will examine the dispute. In order to select the members of the panel, we have a roster. According to the protocol, the Secretariat shall entry into force. The agreement was into force since what date? So, upon entry into force, establish and maintain as indicative list or rosters of individuals who are willing and able to serve as a panelist, member of the panel. Each state party may nominate 2 individuals every year to the Secretariat for the inclusion in this roster, indicating their area of expertise related to the agreement. The indicative list or roster of individuals shall be submitted by the Secretariat for consideration and approval by the DSP, Dispute Settlement Body. The individuals that are listed in the rosters shall have expertise or experience in law, international trade, other matters covered by the agreement, or the resolution of dispute arising under international trade agreements. They are chosen strictly on the basis of objectivity, reliability, and sound judgment, impartial, independent of, and not be affiliated to or take instruction from any party, and comply with a code of conduct to be developed by the DSP and adopted by the Council of Ministers. I looked for, I did not find it. This code of conduct. I don't know if it was adopted or not, but I am not aware of the code. I am aware that there are some states nominated candidates. So they nominate the candidate that are supposed to observe the code of conduct that we don't know. So we nominate people, but those people, according to the protocol, must comply with the code of conduct. The code of conduct did not exist yet. Understand? I tried to find the roster on the website. Unfortunately, I did not find it. I know from LinkedIn 2 years ago that there is a letter from a country, I think Egypt, that in this letter Egypt invited potential candidate to be included in the roster. Egypt invited people that they think that they fool or they met the condition of the protocol to be candidate. Then the Egyptian government, I suppose that they select 2, they can select 2 per year in order to be included in this roster. I think that African countries must be very transparent on the selection of the members of the roster. Some of them, they nominate friends. Some of them, they nominate parents, children. It's better to create a commission or a committee to select people from each country that could be included in this roster. 2 individual per year, and we have a list. So we have how many members now of the agreement? 50 they signed, but 48. So 2 per year. Normally, if the agreement was enforced now, we should have 2 per each country per year. Normally now we have at least 200 or 300 names in this roster, but the roster I did not find it. I found the minister, the secretary was with the ambassador, very nice photo. And you look at the site, every day they put photos. But the roosters, they forget it. I'm not sure if it exists or not. And if all countries, they nominate in this roster. I will tell you a joke then, when I finish this presentation, but I can't tell it now. So, the members of the panels are experts on trade. Then we have an annex that provides that those experts can refer the matter to other experts. So they are not expert enough to decide the case. You know, we have experts, they refer to other experts. So if they are experts, maybe on some technical matters, but that's strange that they are supposed to be expert. And you find this in Africa, many countries, the judge cannot decide without expert. He needs expert. He's a judge. He was supposed to know, to understand. So they use expert very easily. If there is a problem, let's nominate expert. So those people must meet the condition here. Objectivity, reliability, sound judgment, impartial, independent. And we have a roster, a list. So we need to choose 3 members or 5. If the dispute is between 2 states, 3. If the dispute is between more than 2 states, 5 members. They are not government representatives. They are not representatives of the organization. They don't get instruction by state parties when they consider the matter submitted to them. They are supposed to be competent, neutral, and independent. Okay. So how to nominate the 3 members in special disputes? The process is not clear for me. Maybe we will help me to understand the process. But me, you know me, I look for the problem in every legal instrument. We have an article on the selection of the 3 members or the 4 members in the protocol. So what you find is if there are 2 states in disputes, you need to select 3 members. If more than 2 disputing state party, 5 members. Okay. First, this is clear. National of third states, in order to preserve the impartiality and independence, those things, national of the disputing states could not be selected as member of the panel. If you have a dispute between Tunisia and Kenya, you have to select as a member of the panel members from the roster from other countries. Nigeria, South Africa, I don't know. According to the protocol, the Secretariat proposed nomination for the panel to the parties to the dispute. I understand that. The Secretariat proposed. The parties to the dispute shall not oppose nomination except for compelling reason. Okay, I understand that. So the Secretariat will propose 3 names if we have a dispute between 2 states. And the parties should accept, except their reason, compelling reason. Okay. Then you find in the protocol, if no agreement is reached on the composition of the panel, within 30 days, after the date of the establishment of a panel, at the request of either party, the head of the Secretariat, in consultation with the chairperson of the dispute settlement body and with the consent of the disputing state party. I did not understand what is the meaning. Do you need the consent of the state or you don't need the consent of the state? Shall determine the composition of the panel by appointing the panelist considered to be most appropriate. The chairperson of the DSP shall inform the state parties of the composition of the panel none later than 10 days after the date of the chairperson receive such request. Let me make it very easy for you. I propose this practical exercise and I will ask you to answer. If your answer is good, you have the right to go to the break. If no answer, the break is prohibited. You stay here, you take water. Better than coffee, better than tea. So you have the protocol with you. Please look at it, the protocol. And find the appropriate article. I did not give you the appropriate article. You have this case. So 2 states are members of the African Continental Free Trade Agreement. They are in dispute, State E, State B. State E claims that the State B has violated the national treatment obligation. Consultation between the 2 states filed. State E requested the establishment of a panel under the dispute settlement system of the African Continental Free Trade Agreement. The Secretariat then proposed 3 names from the roster of panelists. However, State B rejected all 3 proposed candidates. In light of Article 10 of the African Continental Free Trade Agreement Protocol on rules and procedures on the settlement of dispute, you are invited to determine if this refusal can block the establishment of the panel. You understand the scenario? State said, no, this man is not competent, this man is not good, this member is stupid, this man is have known the knowledge, and it cannot decide on this serious matter. Block it all the process. Why I ask you this question? Because I cannot understand Article 10. Maybe I made a mistake. Maybe you understand what is said in this article. Because I don't understand if the consent of the state is required or not. If who nominates? The provision is not clear for me. Yes. But please, you, please, no. Let the people thinking about, you are a professor, you know everything, you are good, you are beautiful, you are intelligent, you are clever. You know that. Wonderful. But here we are with people in training, so I prefer that the opportunity is given to the people that are participating. Then I can give you the right to comment if I think that is appropriate. You know me, all the time, when I take obligation, I limit it in order to get the freedom to decide. So, look at this article. Who thinks that the consent of the state is required? Who think that is not? Maybe we can interpret it. You have an answer? Yes, please. But read the article before, in order to help people that did not find it to follow you.
Okay, so it's Article 10, 6 and 7. So 6 says the Secretariat shall propose nominations for the panel to the parties to the dispute. The parties to the dispute shall not oppose nominations except for compelling reasons. So it appears the state can oppose the nomination except the reasons should be compelling.
Who determined that the reason is serious and not serious?
7, if no agreement is reached on the composition of a panel within 30 days after the date of the establishment of a panel. So the start of this paragraph also shows that a state can oppose. At the request of either party, the head of the Secretariat, in consultation with the chairperson of the DSP and with the consent of the disputing state parties, shall determine the composition of the panel by appointing the panelists considered to be most appropriate.
There is another word, with the consent of the state. There is another word in the article, in the provision. Read it completely. With the consent of the state.
I've read, and with the consent of the disputing state parties.
So, how to deal with this problem? The state did not give its consent. The first list proposed, the state said, no, they are not good. They are not independent. Who decides? If the reason invoked by the state are relevant or not relevant. That's the first issue. You need to see the issue from practical point of view. You know that the text provides something, then the practice is another thing. If the state, they have dispute, they will use all the reason to avoid disputes, especially in our African context. Then, okay, there is no agreement on the first. So, if you think about it logically, in a structured manner, okay? The first list proposed, the state said that there are reason to exclude them. The reason could be true, could be not. Could be relevant, could be not. This is okay, I understand that. But me, I cannot understand who will decide if the reasons are relevant or not relevant, because we say that the state can oppose invoking relevant reason, or I don't know what they said in their agreement. Then the problem is not if the state can or cannot. The problem is who determines the relevance. Because we know that we invoke reason, we said that. Who decides? Who determines? Then we move to the other step. If there is opposition, the secretary, or I don't know what is the authority, nominates, but I have the impression that we need again the consent of the state. What does it mean? If the state objects, no, we don't accept those people. They are not good. They don't meet the conditions. Expertise, what is expertise? How to prove expertise? This man has not the relevant. He unable to understand this problem. How we behave? Any other answer?
Yeah. Of course, I think the provision is problematic because it makes it appear, or it's mandatory that the consent of the disputing state parties must be obtained. But it's problematic, and I think we can all see that. But at the end of the day, I guess a decision would have to be made. So you have the head of the secretariat, you have the chairperson of the DSP, and you don't have the consent of the state parties. So what do? You have to make a decision. So what is it that we are saying?
I don't know. But if I am state and they have a dispute, I will block all the panelists, all the members. I said no, I don't accept. Yes, please, another comment. Maybe we made a mistake. I don't know, but it's not clear for me. I don't understand.
Yes, it's not clear
at all.
So what would be going forward? For example, a decision would have to be made, isn't it?
I don't have an answer. I ask your help. Me, really?
I would go with the majority. Yeah. If the head of the secretariat and the DSP.
What is your name? What is your name? Your name?
Corinne.
Corinne, I understand, but you know we are lawyers. You need a base.
Yes, we are lawyers and we have to make a decision, isn't it? We have to. So if the head of the secretariat agrees, the chairperson of the DSB agrees, and there's no consent, look at the majority, because those are the three, I think, institutions or officers that have been given that mandate. Because we can't just say the dispute will not be. What do we do?
I understand. This is a good solution.
Going forward, what do we do? How do we resolve this?
They should remove with the consent of state, because if the state is... They said in the extent of possible, or some words in order to make the consent of the state is not binding. So some words like that, the secretary try to take into consideration and nominate, but we cannot put with the consent of the state. Our friends from Cameroon, maybe you have a comment.
Professors.
Yes.
I just wanted to add a comment,
yes,
Professor.
please. You have a priority. Yes, please.
Yes, I note that the example that you gave is with regards to competence. I think we are overlooking one thing, and that is Article 10.3. So I think if it's on the basis of competence, I think Article...
Or independence. So I don't know.
Yeah, but if it's to do with competence, I think we are covered under Article 10.3, which provides, it's in mandatory terms that these people on the panel should have qualifications and expertise. So I would...
Who determines?
Who determines? It's the secretariat, obviously, people who apply.
But why you give the state the right to object if the secretariat did determine and its determination is good? If you give the state the right to object, that means from a logical point of view that we suppose the secretariat sometimes made a mistake. That's why we give the state parties the right to object. That means, think about it, that means that sometimes we have problems. And you know better than me that those people, some of them, they don't have the knowledge. I know them. I know Africa. I was arbitrator in many cases in Africa. We have a roster, I don't give names. We have the exit, for example, list. And I asked, I cannot give a name, but someone from the World Bank, why you don't nominate African in exit matters, in exit dispute settlement? The responsible told me the problem is that when the secretariat, the exit secretariat nominates arbitrator, they have to select the arbitrator from the list, from the roster. And when you look to the members that were nominated by African, believe me, 80% have no link, no relationship with arbitration, with exit, with investment dispute. And they were nominated by their own states. You can look to this list, to the exit roster. You find public servant, judges, family judges. One of them, I Googleize him. He's a family judges. Oh my God, he cannot understand investment issue, BOT issues. So they said that they are competent. Last comment from our friend from Cameroon, maybe he will give us the solution. Then I have a good news for you.
Thank you.
I have two news, good and bad. We finish this and I will tell you the bad and the good. Yes, please. Even if the mic is tired.
It is not my view, it's my understanding of that provision, Article 10, paragraph 7. It says that if no agreement has been reached on the composition of a panel within 30 days, that the secretariat, the head of the secretariat, in consultation with the chairperson and with the consent of the disputing party, so the disputing party must
what?
They must consent.
Please repeat it because I don't follow you.
According to my reading, they must consent to the fact that the Secretariat and the head of the DSP can choose on their behalf.
I don't know.
That's my understanding of the...
I don't understand the same thing.
Yes.
I don't understand.
We are lawyers, so we may disagree.
I don't understand. Me, if I am a state, I will block all the panelists.
No, we can...
And I will ask That's unbelievable. Why? Because there is a dispute on the interpretation of this provision.
Yes.
There is a dispute. So we need the panel, but the state blocked the panel. So we don't have, even if the possibility to constitute a panel to decide on the meaning of the provision. This is a very difficult provision because there is a problem on the nomination of the panel that is supposed to settle the dispute, but the state blocks the panel that will decide on the issue. Oh my God!
Yeah, but that's an interpretation, right? I mean, interpreted in different...
There is, I understand, but there is ambiguity. Who will decide?
Yeah.
The panel. But the panel, the problem is regarding the composition of the panel. I accept all other problems. I will be happy to find another provision. The panel is constituted, but here the matter is very serious. It's related to nomination of the panel. Who interprets? Who interprets? I understand. I can say the parties must accept only the condition, but not the person. As a lawyer, I can find the solution. I can use it or interpret it to give the Secretariat the power. I can do it. I can. It's not so difficult, but please recognize that there is some ambiguity. There is some ambiguity, and it is not. It's not good. This is not good. This is problematic. Who writes those things? He was, I don't know, he drink what he drink, coffee or I don't know.
With all due respect, may I interject?
Yeah. Please.
First of all, understand one thing. These documents were negotiated by all partner states, or rather member states of the African Union. Each country had a representative. Each country. And it was not a question of whether one is present or not. Funding was given to all member states to send representatives. Now, a negotiated text, you have to come to a balance, understanding either side of the coin. You have to, that is why negotiation allows for constructive ambiguity. It is a concept allowed in international law. This particular provision, Article 7, yes, we recognize that the parties may not be able to agree, the disputing parties may not be able to agree on the panelists. And for your information, countries were also allowed to nominate persons, and persons who, they send their CVs. So definitely you look at it to see who are the people who have been nominated. I'll answer a few other questions that you have raised at a later stage. May I finish?
Yeah, please, go on, you have the time.
When it says, if no agreement is reached on the composition of a panel within 30 days after the date of the establishment of the panel, at the request of either party, the head of secretariat, in consultation with the chairperson of the DSP and with the consent of the disputing parties, this consent is to allow the chair of the DSP and the head of the secretariat to select the panelists. So let's not try to create problems, even when they are not.
Thank you for this comment. You mentioned that we have the CV of the listener. As I told you, the names of the listeners are not available, so we don't know who are. Your lecture is, I understand that.
Prof, can I just add something to what she has said?
Yeah, please.
From the interpretation of statutes and instruments perspective, I think words are interpreted using their ordinary and natural meaning. And where there's an ambiguity, like in this case, if you look at the purpose, the purposive interpretation of that provision. At least that is what applies in Zambia. So considering or taking it from that perspective, and that's why I said going forward, of course we recognize that there's a problem, there's a challenge, there's ambiguity, but how do we resolve? If I was to be asked to interpret this provision, I would say, using the ordinary and natural meaning of the words used, obviously there's ambiguity. So in that case, you move to the next stage of interpretation, which is a purposive rule of interpretation. And I'll go with what everybody has said, that when you look at the start of that provision, it says if no agreement is reached. I would go with the majority, which is the head of the Secretariat in consultation with the chairperson of the DSP, if there is no consent of the state parties.
I understand. Just to finish, to close this issue, definitely, in the World Trade Organization system, we don't have this ambiguity. We don't have. There is no consent, the panelists will be nominated without any. They are nominated without any problem. So, if you are happy with the instrument, I am happy. I am not here to destroy anything. I am here to make the instrument good, clear, easy to understand, and easy to enforce. I was not involved in the negotiation. I have the right, as expert, as a professor, to give my opinion. I respect all the other opinions, all the other lectures. If you think that the instruments are good, I am happy for you. But, as an expert, I have the right to make critics. This is important for the evolution of international trade law, for the amelioration of our rules, for the good administration of our system. We are here not to say that is wonderful, that is good, that is nice, that is fabulous. We are here to think, to discuss, to mention the problems, the difficulties. I have all respect to the negotiators, to the drafters. On personal, I respect them personally. But as a professor, as expert, I have the right to mention. I am open to other positions. And I look for the perfection. Ambiguity